Welcome to FedSoc Forums, a podcast of the Federalist Society's practice groups. I'm Nate Kazmarek, Vice President and Director of Practice Groups at the Federalist Society. For exclusive access to live recordings of FedSoc Forum programs, become a Federalist Society member today at fedsoc.org.
Hello and welcome to this FedSoc Forum webinar call. Today, November 21st, 2024, we're delighted to host a Courthouse Steps oral argument program on Delligatti versus United States, which was argued last week before the court. My name is Kayla Kleist, and I'm an Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the expert on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, I will keep my introduction of our guest today brief, but if you'd like to know more, you can access his impressive full bio at fedsoc.org. Today, we are fortunate to have with us Robert McBride, who is partner in charge of the Kentucky office at Taft, Stettinius, and Hollister, LLP. Prior to his time there, Bob was an assistant United States attorney in the Eastern District of Kentucky for over 15 years. As an AUSA, he first chaired criminal jury trials in the U.S. District Court and handled appeals before the Sixth Circuit. Additionally, he was the district's national security prosecutor and the coordinator for the Anti-Terrorism Advisory Council. During his tenure as an AUSA, Bob also held several leadership positions, serving as a manager of the London branch office, criminal chief, and as supervisor of the Fort Mitchell branch office. Bob also formerly served in the United States Navy's Judge Advocate General Corps for over 10 years. And I will leave it there. A last note, and then I will hand it off for a set of opening comments. If you have any questions, please do submit those via the question and answer feature, so they'll be accessible when we get to that extended portion of today's webinar. With that, thank you all for joining us today. Bob, the floor is yours.
Thank you, Kayla. Happy to be here. We're going to talk today about Delligatti versus the United States. This case involves an interpretation of the phrase crime of violence as it's used in 18 U.S.C. 924C. Before we get to the case, I want to make some quick comments about 924C. This is a statute that imposes mandatory minimums on someone who uses or carries a firearm or possesses a firearm in furtherance of either a crime of violence or a drug trafficking crime. The impact of a conviction under 924C provides for concurrent sentences to any other term of imprisonment, whether it's state or federal. And those terms are a minimum of 5 years consecutive, or 7 years if the firearm is branded, 10 years if the firearm is discharged. So these have significant impacts on a drug trafficking case or a crime of violence. With respect to a crime of violence, there are essentially two clauses that define the crime of violence. The first one is called the elements clause. And the relevant language here is one, attempts to use or threatens to use physical force against the person or property of another. If you look at the statute, you'll see there is another clause under subsection 3B, which it's called the residual clause. And I read it here because I think in the context of the discussion, it will grab your attention. The relevant language is, by the nature of the crime, it involves a substantial risk of physical force against the person or property of another person, may be used in the course of committing offense. Now, the residual clause has been attacked under U.S. v. Davis, and it has been found to be unconstitutional because the word offense is very generic and can apply to general crimes such as fraud or theft. And it can also deal with the act or a specific occasion. So the court found that it was unvague under the due process and separation powers and principles. The presumption of constitutionality cannot be applied by a case-specific approach rather than the categorical approach. The reason I raise this is because as we talk about the argument, you may start to sense that the government's argument really would be saved by the categorical approach, which is unconstitutional at this point. So let me talk about the facts of this case. Salvador Delligatti was a member of the Genovese crime family in New York. And that crime family is a member of the larger network of organizations called La Cosa Nostra. Delligatti worked for a guy named Robert Bello, who was a made member of the family. I'm assuming made member means the same thing it might mean in The Godfather. And they were involved in criminal activity that involved running illegal sports gambling operations in Queens. In 2014, I laugh because this is as though it's out of a movie. A fellow named Joseph Bonelli began harassing the owner of a gas station that was frequented by Delligatti. Also, Bonelli was suspected by the family of cooperating against known bookies in the neighborhood, which at some level made him a threat against the family's gambling business. So the gas station owner got sick of dealing with Bonelli, and he paid Delligatti to have Bonelli killed. Delligatti had to give some money to his boss, Del Bello, to get permission to kill Bonelli, and Bonelli had a companion. Delligatti then turns around and he pays $5,000 to the Crips to get together a group of their gang to commit the murder of Bonelli. So Delligatti gives him not only the $5,000, he gives him a .38 pistol, he gave them a car, and he directed them to go and kill Bonelli. So the crew then went to Bonelli's home and they waited in a parking garage that was around the parking lot of a corner around his home. Their plan was to ambush him. So when Bonelli arrived to go into his house, he had somebody else with him. So the crew decided, well, there might be a witness, so we're going to call it off. They go back to Delligatti. Delligatti says, well, go back today and do it. They said no. They go back the next day. And so when they do so, they all assemble at Bonelli's home. On the way there, Delligatti is telling him what to do and when to meet. They have with them the gun, a change of clothes, a spray bottle, and bleach in their possession. The speculation is the bleach and the spray bottle and the change of clothes. Change of clothes were probably to avoid detection, the spray bottle and the bleach to clean up. I'm not sure what they were going to clean up. However, fortunately for Mr. Bonelli, law enforcement had found out about the plot and they stopped the assassination attempt. So Delligatti goes to trial in the Southern District of New York, and he's charged with various things: RICO, operating an illegal gambling operation, conspiring a murder for hire in violation of the Violent Crime and Aid of Racketeering Act, and it's a murder premised on the New York State statute, one count of carrying a firearm in relation to a crime of violence, which is the crime we're going to talk about today. It gets before the Supreme Court. So by way of background, the court uses a categorical approach when evaluating the remaining portion of the definition of a crime of violence. And in that approach, they essentially say the government has to prove, they look at the elements of the offense that the government has to prove beyond a reasonable doubt. They don't look at the actual underlying facts of the case. What does the government have to prove? So Delligatti was convicted on all counts. The 923 was supported by additional conspiracies I didn't list, but the only remaining one is the Vicar attempted murder because Davis made the residual clause unconstitutional. Delligatti claims that the 924C can't stand under the remaining clause because he did not use physical force. He loses down at the Court of Appeals on a split issue, and it comes to the Supreme Court on a petition. There is a split in the circuits, and both the circuits that disagree have kind of run the issues to ground. And so the issue is ripe for the Supreme Court to take. The question presented before the Supreme Court is whether a crime that requires proof of bodily injury or death can be committed by failing to take action, has an element of the use, attempted use, or threatened use of physical force. So here, their argument is that the New York statute cannot have the omission to do anything by Delligatti to stop the murder. Delligatti would have had to have done something himself to have committed a crime of violence. So the petitioner breaks down his arguments in a couple of ways. First, they argue that plain language of the text requires some affirmative conduct. In other words, he must threaten the use of physical force against a person or property. That other statutory clues from the plain language of the text indicate so. So in other words, we're talking about firearms and the use of firearms in crimes of violence, where there must be some proactive use of the firearm. And you see that's related to the statutory minimums, whether it's used, brandished, discharged. Those things can support the fact that there must be affirmative use of the firearm. They argue the government misreads the text, practical considerations of the result of the 924C analysis. That is, if the court finds that the use of physical force does not include an omission that would make the 924C inapplicable here, does not justify the fact, is not justified by the fact that there is a murder that's committed here, or more simply put, you can't punish somebody more if the statute doesn't cover the crime. The government argues initially causing a death, any intentional causing a death requires the use of physical force. And this first argument is really where a lot of the Supreme Court's questioning of the government and petitioner to a lesser degree focuses. They also argue that intentionally causing death requires the use of physical force against the other. So there's use of physical force. The law of murder traditionally viewed omissions as an act. In fact, the government attached all murder statutes from all 50 states to their responsive filings, and that failing to include omissions would undermine the 924C statute. They also argue the petitioner's reading of 924C is textually and practically unsound. Physical force does not require external physical conduct, another place that they're challenged in the argument. And they claim that petitioner's narrow use of force against another person is not supportable. It's unclear what their argument there is, in my view. And then they argue the view of 924C, petitioner's view of 924C structure and hereditary or non-contradictory, and then they view the rule of lenity does not apply. I think I left out that the petitioner claims the rule of lenity does apply. So, not surprisingly, the Supreme Court doesn't get to all of the issues. And this was, I think, a pretty hot bench. The petitioner starts his argument essentially that the use of physical force requires the defendant to take some step to bring the force in contact with the victim. And that hiring another person to have somebody killed does not have an element of the use of force of violence. So the petitioner is not arguing, for clarity purposes, that Mr. Delligatti did not commit a crime. He did commit a crime. What he is saying is that the 924C does not apply because there is no use of force against another person. And that because an omission, in other words, a reason not using force, is not the use of force. It almost seems self-evident, but when you argue it, it can become confusing. Right. So he gives examples. Petitioner's counsel gives examples. First, there's the example of violent force. If you take the gun and you beat somebody with it, that's the direct application of violent force. But there can also be gentle force. And this is the classic octogenarian is standing at the top of the steps. You give them a nudge, a gentle nudge, and they fall down the steps and are injured or killed. There, the act, the application of the force, though not direct, is the gentle pushing. The violent force comes from the action of gravity and the injury caused by falling down the steps. So while physical force is not directly, may not be the initial contact, it must be caused by some action by the defendant. The other example that's classic is shooting somebody. You pull the trigger of the gun, projectile leaves, and hits the person that you aim. The force is the velocity and the mass of the bullet hitting the body. But you pull that trigger in order to activate the force. Not surprisingly, Justice Thomas starts with another classic example or test, which is the act of poisoning. Now, the Supreme Court has said that the act of poisoning is the use of force. And this is, again, that sort of indirect force. When you cause somebody to take the poison or be poisoned, the poison itself is an act of force or physical violence against the person, the biology of the person causing death or injury. The petitioner says to the court, look, this doesn't fall into our definition. Here, again, it's the act of giving the poison that is done by the defendant that triggers the definition. Where somebody simply perishes and somebody does nothing, the petitioner says, involves no use of force by the defendant. Standing by is not enough. In other words, the act of omission is not enough, even in the event that they have some duty of care. And later we'll talk about the Good Samaritan theory. Justice Sotomayor says, well, if you don't have a duty to act, are you responsible for the death? And the answer is no, because you have not applied any kind of violent force. Justice Sotomayor then goes to the freezing example. If there's somebody is out in a violent weather form in the snow freezing and you do nothing, are you criminally culpable? Well, if you have not put that person there, locked them out of the house, pushed them into the snow, then under the petitioner's theory, no, you have simply failed to act. Justice also has a very interesting discussion about, okay, we've talked about poisoning somebody. What if you put poison in the refrigerator and put it in food, put it in the refrigerator, and the victim comes along and eats that food? Interestingly, here the petitioner says yes, that would be the use of physical violence or physical force, violent physical force, because they took the act of putting it in the refrigerator for the victim to consume, and therefore the later force would be the poison. So the gravamen of the petitioner's position is that you must do something in order to trigger force. Justice Gorsuch has a couple of interesting hypos. So the first one involves, and this is the petitioner, an old lady who's crossing the road, and the defendant does not stop her because he has some animus against her. And she falls in to the manhole and is killed. Assume the Good Samaritan law applies here. The first inquiry is, okay, what's the physical force? Well, the physical force here is the gravity and the impact of the old lady hitting the ground. That is a physical force that is not under the control of or is triggered by the defendant by doing it. So, and this leads to Justice Jackson, I think, really sort of hitting the nail on the head. So she says, look, so what you're really telling us, there's no actus re. Even if there's physical force in the context of holding a firearm or dealing with a firearm, you haven't done anything to cause the physical force. And I think that really is sort of the gravamen of, or the fulcrum on which these arguments involve. So if you don't set something in motion to cause physical force, then according to the petitioner, you don't meet the definition of a crime of violence under 924C. Justice Jackson goes on and talks a little bit about congressional history that was raised by the petitioner in his petition. And in that, they take a look at, there's some congressional history when 924C was coming along under the Criminal Code Reform Act, where the hypothetical in the congressional record is, look, somebody is a dam operator, they open the dam, and it kills people as the water floods, right? And the argument is, even though he opened the dam, he was not using the physical force against anyone. He simply opened the dam. And so, while there was violent physical force, he was not using it in that way, which I think is a little counterintuitive, but it seemed to be something Justice Kagan noted in the briefs. One thing I'd like to note is, the Supreme Court has looked at the term use in the context of 924C, and it's mentioned in the brief in Bailey versus the United States. Bailey is actually two companion cases. And the term use is not with regard to firearms, but the use of, a crime of violence, but really the use of firearms in a drug felony. So in these cases, Bailey was arrested for drug possession, and at that time he had a firearm, a pistol in his car, and was charged with a 924C. The other defendant, a woman, was arrested for possession of narcotics, and she had a firearm in her closet. And what the court basically said was, use means some active engagement with the firearm. And I think that is going to be influential in the court's decision here, because essentially what the petitioner is saying here is the defendant must somehow engage physical force. They must use physical force in order to cause the injury or the murder or the death of the individual. Not surprisingly, the United States takes a different view. Now, my view is that the United States is a very uphill battle here. Remember that the 924C charge was upheld in part initially on the residual clause. So what the government is left with is arguing the elements clause. So they assert first and foremost that any type of murder involves the use of violent physical force. And this is, as you can see, that's really sort of the residual clause. It's not the elements clause because there is no omission in there. They argue that the statute doesn't support the defendant's meaning. They argue that an omission is an act. They argue that there's case law, Castleman in particular, that supports the proposition that any sort of injury can be caused indirectly, and that's the use of physical force. Although the petitioner's response to that is Castleman is expressly limited to the area of domestic violence. They argue the petitioner's reading of 924C is unsound. So the Supreme Court really sort of focused on the government much more so than they did our friends, the petitioners. Let me focus on one hypothetical that I think expresses a lot, that deals with a lot of the issues. So Justice Gorsuch came up with originally the lady falling in the manhole. And the government's argument there was, well, even though the Good Samaritan had a duty to act, by failing to act, he uses the natural forces of gravity. And so how they define use is a passive use. It's almost a proximate cause use, as Justice Sotomayor points out. But Justice Gorsuch is not going to let it go. He comes up with another hypothetical to kind of explore use and physical force at the same time. So his hypothetical is that there is a lifeguard at a pool. Now, obviously, a lifeguard has a duty to help anybody in the pool. Her enemy goes into the pool and starts to drown, drops to the bottom of the pool and expires, and the lifeguard does nothing. So the first issue is, what's the physical force? And the physical force, as we've talked about some of these other hypotheticals, is the individual drowning. The water filling the lungs, the gravity dragging them down, and the process of drowning in the physical body, to expire the individual. So the issue becomes then use. How is the defendant, or in this case, the lifeguard, using the gravity? Now, the government argued, of course, the same thing, that, well, the use was permitting those elements to go. And interestingly, Justice Gorsuch asked a couple of questions like, well, you agree with gravity is one of those forces? Yes. Did the lifeguard somehow enable the gravity or create it to be there? And of course, the answer is no. So this attacks how the government's definition of use by omission, because they haven't really created or caused the use of these elements. Something just happened. The individual drowned. Most of the argument, frankly, goes against the government. The government can't quite seem to explain how an omission is use of force. They get past the definition of violent physical force because I think there's a general agreement, even with the petitioner and the court, that you can have violent physical force that the individual does not, who is at issue here, the defendant, does not cause it to happen. Gravity, a car rolling downhill, somebody drowning, the bullet hitting a body. So that issue of violent physical force is fairly well agreed to by the parties in the court. The issue really is what constitutes use, and whether failing to act is in fact the use of a force one does not directly control. So the court does ask about divisibility of the statute. That doesn't seem to go anywhere during the arguments. The court also notes that it is concerned with the fact that an omission is close to use. And when you're dealing with a murder charge, frankly, you don't really want to find an excuse to help a murderer. At least that's the way I viewed it. At the end of the arguments, the petitioner came back with pretty good rebuttal. First point was the elements clause requires the use of physical force to be an element of the underlying crime. In this case, the conspiracy to commit the murder, there is no force directly applied by Mr. Delligatti. That's not true of the men. If they carried out the murder, that would not be true of the men who were actually committing the murder, because they would be using the force, presumably shooting the victim with a 38. Secondly, they argue that use means active employment. And here we're kind of back to the Bailey argument about the active employment of the firearm. Here, its use means the active employment of the physical force, even if it's indirect physical force. Then they discuss the Castleman examples, and those examples that were raised by the government all deal with indirect actions causing the force, pulling the trigger of the gun, introducing a disease to the individual, all things that take a proactive step that causes the victim to be in contact with the violent physical force. And then they end with the octogenarian who falls into a coma. So in this hypothetical, they say the octogenarian who falls into a coma and expires because he's not fed nutrition is not a crime of violence. So they hit use, affirmative use or affirmative action to employ and therefore use the violent physical force, and then the definition of violent physical force, and they end with that. So if I had to bet, I think that the petitioner is going to prevail in this case. I think that the court is going to define use in this context as a defendant having to take some act that engages the violent physical force. It may not have to be a direct act, but sufficient act that the violent physical force is applied against the victim. So, Kayla, do you have any questions?
Well, first off, I'd love to say thank you so much for that summary of the case, as well as the oral argument and sort of a pitch for where we may be going. That was all very, very helpful. I'll issue a reminder to our audience that if you do have questions, please do submit those via the Q&A feature. But I'll kick this off with a couple of my own, sort of fleshing out a couple of things you've already brought forward. I know you mentioned both the residual clause and the elements clause as they came up a lot in oral argument and sort of the interplay. And it was mentioned by both one of the justices and by the petitioners, as well as you in your comments, that the residual clause has been deemed unconstitutional. So why are we still discussing it?
Well, I think we're still discussing it, A, because it's been around a long time, and B, because it's difficult to fit the government's argument in the elements clause, and we're sort of slipping back into the residual clause. I kind of expected I did expect the court to push the government more as to why their argument doesn't fit into the residual clause. It's almost as if the government wrote their brief and to apply to the residual clause, and then turned around and said, "Oh, we've got to deal with the elements clause." Now, that may or may not be true. I would note again that the residual clause was determined to be unconstitutional in the middle of the appeal process. I think it's hard when the government has to make a quick change in how it's viewing a particular crime, because you become used to thinking of the elements of the offense or the facts of the crime itself in a certain context. And the residual clause seems so likely because that's an ends result test. If there was violent physical force, therefore it's a crime of violence. And that's really what the government's arguing here. If you look beneath their legal arguments, they're really saying murder. In fact, they do argue murder must be a crime of violence. There must be acts that involve crime of violence. One of the things that comes up in the oral arguments is the court essentially traps the government in admitting that all murders, all deaths end up in a crime of violence because of the physical processes of dying. So, at that point, then you have to limit the theory of, the applicability of use of physical force by the word use and what use means in order to qualify under the statute.
Got it. Thank you. That's very, very helpful. You mentioned, then sort of summing up oral argument, that there were a lot of hypotheticals and analogies coming to both the petitioners and to the government from all members of the bench. Were there any that seemed to stick? I don't know that I got any in my initial read through, but I was wondering if there were any that seemed like they stuck out particularly to you.
Well, I think Justice Gorsuch's pool argument or hypothetical is the one, that he presented it to both parties. And the petitioner's obvious argument was, look, she's just standing by. She may have a duty, but she actually didn't use the forces of gravity in the water drowning the individual, causing the violent force. And the government had to resort to, no, she was in fact using those elements that caused the violent physical force by doing nothing. And if you go to the plain, the government was then asked, well, are you using the plain meaning of the word use, or are you essentially using a legal definition, a legalized definition? He said, well, it's plain usage of the term. The court's reaction was, well, then you're just kind of playing a game with the language, to which the government said, well, essentially, we're always playing a game with language. I'm not so sure how that went over with the court. I listened to the verbal or the audio, and it didn't seem to have a reaction. But I think it illustrates the weakness of the government's position in this case.
Fair enough. A question from an audience member, just clarifying a point. The petitioner's argument is not that active poisoning isn't murder, but rather that you have to have an active choice in order to have a violent crime. Yes? Or a violent murder.
Correct. So the 924C statute is an enhancement for penalties. So if you are convicted of a crime of violence in which a gun was used, you're going to get one of the three different minimum statutory penalties: 5 years, 7 years if it's brandished, 10 years if the gun is discharged, on top of whatever else you're getting. So one can be punished for the murder. In fact, our petitioner here got 240 months on all the other crimes, and 60 months on top of that for the 924C. So he's still being punished, but the questioner is exactly correct. It's not that he didn't commit the murder. It's that he did not commit a crime of violence by committing that murder, thereby making him not liable under the 924C. Boy, that was backwards. But did I make my point clear there, Kayla?
I got it. Sorry,
Okay.
I think we're good. Moving to precedent, you mentioned Bailey and Castleman, and there are several others that sort of burbled up throughout oral argument. Was there any one or a couple of cases that seemed to be controlling for the justices, or is there more first impression and we're pulling alternate legal theories from other parallel circumstances?
Yeah, I don't think there's anything that is controlling or precedential here. I think Bailey will end up, although it wasn't discussed too much either in the briefs or in the oral argument, I think Bailey will end up being influential because, first of all, it deals with the same statute. It defines use as including some engagement of the firearm. Here we're talking some engagement of physical force. So that context, I think, is going to be important. So you have engagement of the firearm and the drug trafficking crime. Now you're going to have the engagement of something that causes the physical force. I think there's continuity there. And I think the plain meaning of the word use, right, is going to be the same in both places. You know, it's interesting because there are other statutes that materially have the same kind of language. You know, the Armed Career Criminal Act, Hobbs Act, there's a section of the INA that uses crime of violence, all of which involve the use of crime of violence. And so in the ACCA, the use of crime of violence has been defined a little bit further. Some of that's been found unconstitutional because there's a residual clause there. But I think they're going to end up having to have use mean engaging something that causes the physical violence, causing the death or whatever it is, because it's consistent with the statute. You can't use a firearm. You can't just possess a firearm and not use it to commit the crime of violence.
Continuing on that, so you've mentioned there's parallel statutes that have similar or this same crime, but in other statutes. How does this oral argument and particularly the trends in questioning from the justices potentially affect not just this case, but petitioners who may be bringing cases under parallel statutes and the way they're thinking through what arguments they should be making?
I think that if the court rules for the petitioner, it's going to further narrow the types of statutes that could be crime of violence under those other areas in very general terms. And I think the court's been moving that way typically. The 924C is a statutory minimum. The other crimes, the ACCA, carries with it significant penalties. The INA statute, it means whether or not somebody's deportable in a certain context. Hobbs Act, similar kind of issues, and enhances the punishment. So I think they're going to narrow use to the plain meaning of the word use within the context of the statute.
Got it. Continuing on this slightly, and I know you'd mentioned divisibility was mentioned and then moved on. Do those arguments matter for future cases down the road, given the fact it wasn't really addressed in oral argument? Is there a world where this isn't particularly helpful for informing that conversation?
I don't think so. It wasn't developed either by the court or by the government to any great degree. It wasn't briefed by either party. It wasn't raised below. Petitioner basically said, look, Judge, we don't want to argue it Justice, we don't want to argue it because we haven't raised it below and we don't think it's divisible. The government, of course, said, we think it's divisible. But I don't know then that unless the court wants to use it as an excuse to send it back for further consideration by the Second Circuit, I think what the court's going to do is say, use, they're going to address the real issue. Use means you have to do something to exert the violent physical force, not just let it happen.
Okay. This is all playing out against the backdrop of a categorical sentencing framework.
Correct. I forgot to mention. Yeah.
Well, you raised it slightly. Actually, my question was coming. The government would articulate they were very constrained by the fact they can't challenge categorical sentencing, at least in this case. Is there a world where that door has now been opened, given some of the questioning? Is the justice are you challenging that? I know there was a little bit of back and forth with the government saying, hey, is this really the argument you're making? And the government denied it, saying they were constrained by precedent. But I wondered if it opened that door or if it's how this plays against that broader conversation.
I don't think so. I thought the government was very contrite about no, Judge, Justice, we're not going there. We lost that fight. We're not trying to get it into the back door. I don't think there's anything that opens those issues back up. I don't think those issues are going to be brought back up before that door is going to be open. I'd be surprised if it's open before this court in any way, and maybe future courts. It's a done deal.
Okay. I have just a couple more questions and then we might wrap early. Were there any arguments you're either surprised to see show up at OA or surprised that didn't get raised?
Not that didn't get raised, but I am surprised that the government really was relaying on the fact you've got murder. And murder is an awful violent crime. I completely agree with that. But I think it misses the point as to the application of the 924C. Is murder an awful violent crime? Of course. But the issue is really, did the defendant do something to cause that violent force to be enacted upon the victim, right? And I understand, when you're the government, part of your job is to do justice. And you can understand why they may genuinely feel that the 924C would be just, but I think that argument missed the boat, and I think it clouded their arguments a little bit. Typically, at this level, you're really just dealing with what the law is and what the impact will be. And here, what is the impact really going to be on Delligatti? I mean, he's going to do 240 months as opposed to 300 months. That's a significant sentence. I don't know how old Delligatti was, but there are people who wouldn't survive a 240-year, sentence.
Okay. Well, I know you've given us, I'm always at the end turned to sort of prognostication and what could come. You've mentioned sort of what happens if the court sides with Delligatti, which seems highly probable given OA, but I'll pose the contrapositive just to see what happens if the court rules in favor of the government.
Before I answer that, I meant 240 months, not 240 years. Well, I think what happens is it opens the door for a lot of definitions of use that probably aren't supported by plain language of the. So, for instance, if you let the old man die of without nutrition because he's fallen into a coma, you could be liable for that, I suppose, under this statute. Or if you let the little old lady fall down the manhole and get injured or killed, I suppose there's a state statute for which you could become liable for that, particularly if there's like a Good Samaritan law that imposes upon you an obligation to help. Are those cases really appropriate for 924C potential penalties? As you and I were talking before the seminar, Kayla, you don't have to charge the underlying crime with a 924C. So you have somebody convicted of manslaughter where there's a Good Samaritan clause, it could be used here if the Supreme Court goes with the government's interpretation. And I think you get on a slippery slope. What then is going to be read into the elements of a crime? Because remember, we're talking about the elements clause here. And the elements clause means the elements of the crime must include the use of a violent force. So I think it gets you going down a slippery slope. Lawyers are, they're going to push the envelope everywhere they can.
Okay. And then last question, I've got you down as it's probably going to go in the petitioner's favor. Do you have any sense of how the court's going to break on that? And if it's not a unanimous decision, and what some of the key issues in the opinions might be? I think it could be a 9-0 opinion. Justice Sotomayor was probably asking the most critical questions of the petitioner. And those were essentially, well, are you arguing proximate cause here? Are you arguing that if your client didn't cause something, they're not the proximate cause? But I think that argument, even though I think it was posed to challenge the defendant, or pardon me, the petitioner, I think that actually ultimately ended up supporting the petitioner's position. I think the critical issues will be,
plain meaning of the language of the word use, attempted use, or threatened use of violent physical force. I think that it will be found to be consistent with the rest of the text of 924C. And I think it will be found to be a clear definition of violence, of the use of violent crime. And I think in some ways that's parallel to their decision-making process in Bailey, because it gave a clear benchmark for prosecutors to go by. Because before Bailey, they were, anytime you had a gun and you got tagged for a crime, possession of drugs or some other minor or other drug crime, not necessarily trafficking, well, then they tag you with a 924C. And it was, I'm sure these things were done in good faith interpretation of the statute, but the Supreme Court cleared it up. Now you only charge where there's an actual use. Even in the in furtherance of clause for the drug side of the 924C, there has to be some proximity of the gun to the drugs or the cash. It has to be close enough that you may use that gun to defend it. In other words, it's the the fortress theory. But when they defined Bailey's use clearly, there was a better, more effective use of the statute by prosecutors, and defense lawyers were able to defend against it. Here, I think it's the same thing. They define use clearly and what's a crime of violence, then it would be a clear benchmark, which in criminal law, you always want clear benchmarks.
Sounds good. Well, thank you so much. Really appreciate you spending your time with us today and sharing your valuable expertise and insight. I'll say thank you also to our audience for joining and participating. Welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.
Thank you for listening to this episode of FedSoc Forums, a podcast of the Federal Society's practice groups. For more information about the Federal Society, the practice groups, and to become a Federal Society member, please visit our website at fedsoc.org.